is represented that Lieutenant Rendon provided the court with the internal affairs file. Did the court actually review that file and see the substance of what was in it?
I did, and after I reviewed the file, I actually had Miss Wood scan a copy for the defense, which she did. That electronic copy doesn't exist anymore. Sorry.
Judge, you let us copy the thumb drive that was inside the file. We did that here in court, after a hearing. And then that was the day that you had some things to attend to off-site with family. And the next morning, the staff scanned to us the hard copy stuff that was in the file.
Okay.
We got that via email. It was only sent to us. And we've included that and made it before ourselves on our end.
And thereafter, I gave the file back to Miss Rendon, the investigator, who I happen to have worked with before, with the DA's office.
Okay, very good. Thank you, Judge. I just want to make sure that I was clear on everything that had happened. And then additionally, there was an envelope yesterday marked as Court's Exhibit 3 that Lieutenant Merritt had provided. Did the court get a chance to review that?
I have, and I do believe it contains information that is privileged under Garrity or immune from any further use, so I'm going to seal it. It's been taken into evidence as Court's Exhibit number 3, and it's sealed.
Very good. Thank you, Judge. Judge, the state submits to this court that when there is an allegation of a Garrity violation, the defendant has an initial burden of proof of showing that there was a Garrity statement. Then the D.C. Circuit Court of Appeals has held in U.S. v. Slav that the defendant additionally has a burden of showing that if there was a Garrity statement, that there's a firm foundation resting on more than suspicion that proffered evidence was tainted by any exposure to immunized testimony. Once those burdens are met, then the state would have the burden of showing by a preponderance of the evidence that the testimony, either before the grand jury or a trial, was derived from legitimate independent sources. The state submits to this court that the defense has failed to meet either of the first two burdens. With respect to the walkthrough conducted by the Dallas County Sheriff's Office, all of the evidence shows that this was an independent criminal investigation apart from the internal investigation conducted by Balch Springs, that the Garrity warnings given to Mr. Oliver on the morning of April 30th applied to the written Garrity statement that he provided, and that he was in no way threatened with termination for refusing to participate in a walkthrough that he participated in with the assistance of his attorney, and that he had no reasonable basis for believing that he would be terminated or disciplined in any way for refusing to participate in it. So the state submits to this court that that walkthrough was not a Garrity statement at all. The record has also failed to show in any way beyond allegation and suspicion that anyone in the DA's office, except for Investigator Rendon, during the investigation of this case was exposed to a Garrity statement. And she was exposed to the actual Garrity statement pursuant to policies that were put in place to prevent exposure to Garrity statements. And we've shown that Mr. Hermes did not know that there even was a Garrity statement, much less what is. The evidence also shows that 3 people had ever seen the defendant's Garrity statement: Lieutenant Merritt, Lieutenant Hurley, and Chief Haber. So far, the witnesses have all said that they have testified before the grand jury or will testify based on their personal observations that they were there or minor factual details that they discussed with Mr. Snipes. No one was influenced in any way by the defendant's Garrity statement. Jeremy Seaton said yesterday he saw Chief Haber on TV, and Eric Knight will also say that he saw Chief Haber on TV, but Lieutenant Merritt explained that Chief Haber's statement on TV was based on a review of the body-worn camera footage, not any statement given by the defendant in this case. So the state respectfully submits the defense has failed to meet either of their initial burdens of proof, and the state has shown by a preponderance of the evidence that no testimony or evidence in this case is tainted by a Garrity statement. And we would ask that you allow the trial to proceed.
Thank you. Mr. Gill.
And Your Honor, what is clear from the record is that there were in fact 2 separate statements that were Garrity-based, that occurred after Garrity warnings were issued to Mr. Oliver. Garrity warnings were issued at 3:20 a.m. on April 30th of 2017. every statement that was given by Officer Oliver occurred after the Gary warning was given at 3:20 a.m. So we have what has been referred to during this hearing as a walkthrough statement, which was a verbal statement given by Officer Oliver to investigators, and then there was a later on statement turned into Lieutenant Merritt on May 2nd that was in written form. Both of those statements were given after Officer Oliver's garrity protections, his rights under the Fifth Amendment, privilege against self-incrimination, were invoked by the Ball Springs Police Department. Once an individual's garrity warnings have been given, and he is informed that everything he gives from that, every statement he gives from that point on are in fact privileged, and that he has use and derivative use immunity from the use of those statements against him, that is what the law requires. The law requires that no one from law enforcement involved in the participation in the prosecution of the case have any involvement or any knowledge or make use in any form of what's contained in those statements. And what we have here are, with regard to the walkthrough statement given at 5:20 a.m., the state has agreed, and the evidence is clear, that everybody that's involved in the trial of this case has had access to and has viewed and has knowledge of the statements given by Officer Oliver at 5:20 a.m. during the walkthrough. And those include matters that can only be gained from Officer Oliver himself. There's a lot of information in this case that can be gained from Officer Gross. A lot that can be gained from people that observed what happened out there. But Officer Oliver's observations, what he saw, and what he was thinking at the time could only have come from Officer Oliver. And those statements were brought out from him during that 5:20 a.m. walkthrough that was done after his garrity rights were read. He has use and derivative use immunity from everything that was contained in that statement. The state cannot show that they have an independent source for the thoughts and mental impressions of Officer Oliver that were gained during the taking of that walkthrough statement. The Slough case that the state is so fond of citing says that Kastigar, which is the main case that interprets the derivative use immunity that someone has after a Fifth Amendment garrity statement, Kastigar prohibits the use of immunized evidence, which is clear. The evidence that gained from Officer Oliver was immunized evidence. It prohibits the use of the immunized evidence as an investigatory lead to other derivative evidence that would then be used against the defendant. So not only is he protected from the actual use of that statement against him, but he is protected from anything that law enforcement gained or could have gained from their knowledge of that statement. So anything that they could have gained or did gain from their knowledge of his mental impressions or his thought processes during the events that are the basis of this prosecution is prohibited from use by any member of the prosecution team or the law enforcement investigation team that was involved in this case, which is everything here. It's everything that goes from preparation of grand jury testimony to preparation of direct witness examination of any witness that has knowledge of this case, to preparation of cross-examination of Mr. Oliver should he decide to testify, to preparation of voir dire material to question the jury. This whole case, search warrant affidavits, autopsy, everything here is tainted by what came from that interview at 5:20 a.m. The Fifth Amendment garrity rights, the immunization process is like a blanket that was thrown over Officer Oliver the moment that warning was given and carried forth to him until such time as this case is concluded. This information can't be used against him in any source or any fashion. So we'd ask the court to make separate rulings with regard to the written statement that was viewed by at least one member of the Dallas County Criminal District Attorney's Office, which has been identified in previous filings and stipulated to here as Exhibit F, a written statement given by Mr. Oliver, and the 5:20 a.m. walkthrough was participated in by Officer Oliver with the investigatory lead detective with the Dallas County Sheriff's Office. And we're seeking to suppress any evidence or any thought processes or any preparation that was done by the Dallas County Sheriff's Office, the Dallas County Criminal District Attorney's Office, or any witness with regard to this case. We're also going to re-urge our motion to recuse the Dallas County Criminal District Attorney's Office. Now that we've had an opportunity to fully develop the record in this case, which we didn't have at the time the court originally reviewed that or ruled on that motion, and we also would urge a motion to dismiss the indictments in this case because the prosecuting authority and investigating authority here had full and complete knowledge of Officer Oliver's immunized statements at the time the grand jury presentation was made, and therefore any grand jury indictment that came out in these three cases and the other two that were taken under consideration at the same time are all tainted because of the information gained that's tainted that these officers shouldn't have access to.
Thank you very much. The court is not convinced the defense has met their burden proving that this statements tainted the investigation. The court does find that the statement that was given by Mr. Oliver to Balch Springs Police Department at 3:20 in the morning to Lieutenant Merritt, I believe that statement was also given to, or Chief Haber might have been involved in that, but to the extent that he was, that statement in 310 certainly falls squarely in line with Garrity in this court's opinion. But I also find that the Balch Springs Police Department, those that were involved in the internal affairs investigation of this case, Lieutenant Merritt in particular, effectively walled himself off. That the walkthrough that we referred to at 5:20 in the morning, I believe is when we've been talking about that this started, was a separate criminal investigation. I don't think any objectively reasonable person standing in the shoes of Mr. Oliver would have viewed that as an administrative proceeding that would have resulted in his termination. I also believe that the people he was speaking with were in no position whatsoever to have any say-so in his employment status. Fundamentally, he didn't work for them. He worked for Balch Springs. Any statements that he gave and every statement that was shared by the Dallas Sheriff's Office, Lieutenant Carranza, Detective Fetter, and everybody else, I don't believe was improperly tainted by a Garrity statement that was given at 3:20. The walkthrough is not Garrity in this court's opinion. Your motion to recuse is denied. Considering this motion sort of a motion in limine, really a motion to suppress. So your motion to suppress is denied. I haven't heard anything that would effectively challenge any of the personal knowledge of the witnesses. So your motion in limine is denied at this point as well. Then you've got this motion to dismiss that you just orally made.
Judge, if I can respond to that oral motion to dismiss.
I don't think you need to.
Okay, very good.
I'm just trying to think for just a moment. The motion to dismiss is denied. I think that'll take care of that. Okay. Is there anything else before we bring the jurors in? Mr. Gill? Sorry, you stood up first.
May I clarify your ruling?
Sure.
I moved to recuse the Dallas County District Attorney's Office on the basis that their office had access to Officer Oliver's written Garrity statement, which has been previously identified for the court as Exhibit F.
Yes, sir. I recall the exhibit.
And what is your ruling on that specific objection?
Your motion to recuse is denied.
I made a separate motion to recuse the Dallas County Criminal District Attorney's Office on the basis that their office had knowledge of the information gained from Officer Oliver during the 5:20 a.m. walkthrough with Dallas County Sheriff's Office investigators.
Okay.
And will the court make a separate ruling on that motion?
That's denied as well.
We made a motion to dismiss the indictments in this case that are on trial here on the basis of the written Garrity statement identified as Exhibit F.
My hesitation on that is, I don't know if that's in the form of a writ, if that's in the form of just an oral motion to dismiss in the middle of a trial. If it's in the form of an oral motion to dismiss in the middle of a trial, it's denied.
Well, I will have a written motion on file later today, and
All right.
maybe we take the matter up at that point. I mean, I don't think we need to develop anything further. We just need a rule. We'll need a ruling on it.
Well, if you file a motion, I'll consider it. Is there anything else?
We asked you to suppress evidence gained as a result of these Garrity statements. The Exhibit F, the written Garrity statement, we made a motion to suppress the arrest warrants and the search warrants that were presented during the course of this hearing.
Yes, sir.
Do you have a ruling on that?
Your motion is suppress on all of the exhibits, the search warrants, the arrest warrant. I don't recall precisely what the search warrants were for, but every search warrant that you put before the court, your motion to suppress is denied. As well as your arrest warrant, the arrest that was made pursuant to the warrant of Mr. Oliver. It's denied.
Thank you, Your Honor. And I'm now making the same motion with regard to the information gained from Mr. Oliver during the 5:20 a.m. walkthrough.
Yes, sir.
Moving to suppress the fruits of any searches that were conducted under the warrants that were admitted during the course of the hearing. Two searches of the vehicle, 2004 Chevy Impala, and search of Officer Oliver's weapon.
All right. That motion to suppress is denied, and I'll give you a running objection to any testimony that will be heard on those particular issues.
Thank you, Your Honor.
Nothing further, Judge.
All right. Let's call your next witness. Sheriff, if you wouldn't mind calling the jury.